Good afternoon. Welcome to Assembly Natural Resources. Madam Secretary, please take the roll.
Assemblywoman Anderson. Assemblywoman Bilbray Axelrod. Assemblywoman Brown May. Assemblywoman Considine. Assemblyman DeLong. Assemblywoman Duran. Assemblyman Gurr. Assemblywoman Hanson. Assemblywoman LaRue Hatch. Assemblyman Watts. Assemblyman Urick. Chair Cohen.
And I am present. Thank you. A little lay of the land before we get started. We do have to recess at 4:25 to go to the floor to hear Congressman Horsford. We are going to hear Senate Bill 180 first. If we could get done before then, hopefully we can get done before then. If not, we will come back up and hear that. If not, if we can, we will come back and do 269. If not, we will come back and continue with 180. However, just for anyone who is interested in 269, we did just receive a friendly amendment from Senator Orenshaw, which I believe has just been uploaded to Nellis. So if anyone is interested and they want to take a look at that, please feel free to take a look at it. Very brief housekeeping. Please make sure and silence your electronic devices. If you wish to testify, please sign in at the door and provide a business card to the committee secretary. For those joining online, please be sure to mute your microphone when you are speaking to minimize any background noise. When testifying, please turn on the microphone. Clearly state your name and affiliation, if any, for the record, then turn off the microphone each time. There should be 15 hard copies of handouts for the general public, and electronic copies should have been submitted to the committee member by noon yesterday. We expect courtesy when dealing with, in our interactions, whether it's dealing with the public or with each other in the committee. And please note, committee members will be using our laptops. Please don't take that as a sign of disrespect, but we do use that for viewing documents and for communicating with each other. So with that, we will begin the hearing on SB 180, which revises provisions relating to groundwater boards. And welcome, Senator Goygetchia. Please go ahead when you're ready.
Thank you, Madam Chair. Members of the committee will be as brief and as rapid as possible. Senator Pete Goygetchia, representing Senate District 19, and I'm bringing Senate Bill 180 to you today. Long and the short of it, Senate Bill 180 revises provisions relating to groundwater boards. Under existing statute, the state engineer the Board of County Commissioners recommend to the state engineer to create a groundwater board. Then at that point, if he decides to do so, then he goes to the governor. The governor, in fact, appoints one. And just case in point, when I was a county commissioner in Eureka County in the 90s, we did go through this process, tried to create a groundwater board for Diamond Valley. I know a number of you are familiar with Diamond Valley and the issues there. So bottom line is, we never did get a groundwater board in there. Maybe 25, 30 years later, it might have been a benefit, it might not have. I'm not going to say it was. Here at the table with me today, I have Mr. Jake Tippett, and he's going to walk through the bill because he is a lot better at it than I am. But I'm just going to cruise over it for about 2 minutes worth. And, we came out of the Assembly, or out of the Senate, pretty clean on this one, but I do believe we will have some opposition testimony on your side. I want to clarify one point in this bill, that Clark County has a groundwater board that was appointed and created by Act in 1997, but there seemed to be some argument whether Clark County should be in this or shouldn't. But some people I've talked to say, yeah, they want in. Others say they don't want them in. So I think that's the only real discussion we've got with the bill. The rest of it, the appointment of the board members, I'll let Mr. Tippett walk through that. And the bottom line is really what it's about. It allows the Board of County Commissioners to request to establish a groundwater board. The state engineer then has to consider whatever advice. He isn't bound by it. And if he chooses not to follow their advice and act in a different direction, even that isn't subject to judicial review. The board only lasts for 4 years. But again, I'm bringing it for Central Nevada Water Authority. These rural counties want the ability to at least offer some advice on those problem groundwater basins they've got in their jurisdictions. And that's really all I'm asking you to do, and I'll turn it over to Mr. Tippett for the technical explanation. Thank you.
Thank you, Senator. And before you go through the bill, Mr. Tibbetts, I just want to be clear to you and to the committee and to the public. If we could get done in the next little while, that would be great, but we will take the time that it takes. This is an important issue, so I don't want anyone to feel rushed. So please go ahead.
Thank you, Madam Chair. My Board of Commissioners calls me the filibusterer, so I will try not to do that today. And I'm Jake Tibbetts, for the record. I'm the Natural Resources Manager for Eureka County. Eureka County is a member of the Central Nevada Regional Water Authority, and this bill was a request of the Central Nevada Regional Water Authority, and we're very thankful for Senator Goicoechea sponsoring this bill and bringing it forward. The Executive Director of CNRWA, Jeff Fontaine, does send his regrets that he couldn't be here today to step through the bill with the committee. So, Madam Chair, with your indulgence, I'll go ahead and step through it here. But first, just a little background on it. It does amend NRS 534.035 that already exists, where you can stand up groundwater boards. That statute was enacted in 1961 in Assembly Bill 437. And through that process, the Las Vegas Valley Groundwater Board was stood up. The statute has been amended at least 3 times since then, and to our knowledge, there's never been another county groundwater board that's been created under the statute. So under the current law, if the Board of County Commissioners wants to create the board, as Senator Goicoechea mentioned, it has to be approved by the state engineer, the members appointed by the governor. It requires the state engineer, actually has a mandate for the state engineer to confer with groundwater boards, obtain their written advice before making any decisions in the groundwater basin. And there's just a lot of cumbersome things in the current statute that is an impediment to creating a new groundwater board. So stepping through the bill, Section 1, Subsection 2, it enables the Board of County Commissioners to create a groundwater board by making a request to the state engineer, who then appoints 7 members. And so the membership is outlined in the bill. It's made up of a balance of senior priority water rights, junior priority water rights, and then water rights that somebody that owns or holds the majority or the highest quantity of water rights in the basin. Sub 3, Section 1 provides that in addition to the members appointed by the state engineer, the Board of County Commissioners, they can appoint a member to the groundwater board as well, but that member would be non-voting, would just be there kind of as a liaison and an advisory role and to just help to keep a pulse on what's going on. Sub 5 makes it clear that the groundwater board meetings, they would be public meetings, so they would be held in accordance with Nevada's open meeting law. Sub 8 removes the requirement under the existing law for the state engineer to confer with the groundwater board before acting on any application or well drilling permit, or before he orders an order or regulation. And it instead simply requires the state engineer to consider the advice and recommendations of the groundwater board on reducing overpumping in the basin. Subsection 8 also removes the requirement for the state engineer to provide a written report on any disagreement with the recommendation of the board, and it adds language to clarify that a decision of the state engineer to not comply with the recommendation of the board is not subject to judicial review. Sub 9 sunsets a groundwater board after 4 years, unless if the Board of Commissioners and the state engineer approve additional 4-year terms. And it provides at any time that the board itself can dissolve themselves by a majority vote. And then finally, Section 2 removes the state funding for the groundwater board. So it is a fairly simple process, allowing counties to stand up these groundwater boards in partnership with the state engineer. It provides another local approach, grassroots approach, proactive approach to managing groundwater basins, and it can result in more place-based and local decision-making or influence on the decision-making. So some questions have come up. Well, can't the state engineer get input without having to create a groundwater board? Well, yes, the state engineer can do that, but we feel that the legal backstop of state law and having the formal process in place is really important, and it provides more legitimacy to the process. Counties can create any boards they want to, subcommittees or boards, so they could on their own do that, but again, we feel having it in the water law itself, again, provides that legitimate process. Another question that has come up is, what will these county groundwater boards do? Well, they'll use their local knowledge of the local conditions, and they'll make recommendations to the state engineer. They'll be actively engaged in the process to help basins so they don't become overdrafted or overpumped or eventually get to having to be designated as a critical management area. And then another question that we've heard is, well, some of these basins straddle different county lines, and how will that take place? And so it's the groundwater holders in a basin that is the membership of the board, and it doesn't require the membership of that board to come from the county in which the county commissioners stand up the committee. In fact, it has to be senior, junior rights, and somebody has the quantity, the greatest quantity. That could be in different counties. It also does not stop a county. One basin could have 2 groundwater boards for each portion of a county if they wanted to. But frankly, you know, many of our counties do work well together, and there are other mechanisms for counties to work together when they have those basins that do slop across different county lines. So we feel that that is not an encumbrance to the process as it moves forward. And with that, again, I think it's fairly simple. If there's any questions that I can answer, I'm happy to do so.
Thank you. We do have questions. I have some questions from Assemblymember LaRue Hatch.
Thank you, Chair, and thank you both for presenting this. I am delighted that both of you are with us today and we get to talk about water. So my first question is just, how does this make it more streamlined? Because you're saying that the goal is to make it more efficient so that they're more likely to have these boards. What about these changes makes you feel that we're more likely to get these?
Senator Goycochea, for the record, to Assemblywoman Hatch. Realistically, it's been a real cumbersome process, and the fact that we've only seen one groundwater board put in place in the state, and that was by legislative act, I guess, and it's been in place for, we're going to say 60 years. There's probably something wrong with the existing practice, so good or bad, we hope to streamline it, and I believe that in fact it will. Really, it's all about getting people together to confer. Let's talk about these issues, especially in these groundwater basins that are over-appropriated. We need to deal with them. And at this point, we haven't been doing a great job, so we hope to speed it up.
And feel free to go directly to the member.
So, and I appreciate that. I guess my question is, because this is just adding, members to the board and it's changing it to request instead of recommend, are you suggesting that that would change their regulations around these and therefore clean up some of that bureaucratic red tape that's getting in the way?
Madam Chair, Jake Tibbetts for the record. So Assemblymember LaRue Hatch, currently, if you look at the statute as it exists today, to stand up the membership requires a governor appointment. And there's just so many unnecessary steps. And then in the current statute too, it's a mandate for the state engineer to confer with the board. There's written recommendations, and then if there's, disagreement, there has to be, state engineer then has to write down why there's disagreement and submit that as well. So this is more, it's formalizing kind of an informal process, really. It's to get groups together. It is a formal groundwater board, but it's essentially to get folks talking about the issues, try to come up with some potential local solutions, and to have that good dialogue with the state engineer's office in a more streamlined way. It's just simply just trying to make it so that conversation is taking place.
Thank you. That makes sense. I think that helps clarify the streamlining. My next question is just on the members of the board. If you could just speak to your reasoning behind why you chose those numbers and those individuals, and perhaps why it is only water owners and not other community stakeholders that are part of those boards.
Jake Tibbetts for the record, so I'm going to answer all the hard questions, I guess. So Madam Chair, thank you. In these basins that are designated, so this would happen in designated basins, and that's a specific term of water law, that a basin that requires some higher level of active management or management, the state engineer designates those basins. So this would only apply in basins that have reached that higher threshold. And then when we're talking about water management, in times of water shortage, this body has created, I won't call them carve-outs, but protections for like domestic well holders, that in times of curtailment, they're guaranteed a 5 acre-foot allowance for their domestic use. There's also preferred uses that can be designated by the state engineer. And it's essentially, if a basin gets unbalanced or overdrafted, it's the water rights holders that are those that pay the price. And so the balance of the membership is to have more senior rights on there, but also to give junior rights a voice, so there's lesser members there. And then essentially the permit holder, the water rights holder that has the most to lose or gain, or so it's just trying to balance those that are using the most water and then the senior and junior approach. So, and just one more point of focus, that it is an advisory group, right? It's an advisory board. They have no independent regulatory authority. It's to provide conversation and, recommendations, and that's simply all they'll be doing.
Assemblyman DeLong.
Thank you, Madam Chair. I think this will be one for you, Jake. Under subsection 8, it talks about written recommendations and advice regarding reducing overpumping. Are you contemplating something beyond curtailment of junior rights?
Jake Tibbetts, for the record, and Senator Gocochea is reaching for the button. So, Madam Chair, again, Jake Tibbetts for the record. Assembly member, I think that that's the idea, is if there are different approaches than just simply curtailment, there should be a forum for folks to get together to talk about those and engage with the state engineer. But then in some situations, it may come down to curtailment is the only tool. But we're trying to avoid that where possible, where there may be other management scenarios where people can get their water allocation without having to go to curtailment. And that's the idea in some of this, is that there may be local approaches that are supportable by the state engineer and supportable under the water law, that just getting the right people to the table to talk about those is important.
Appreciate that response. Thank you.
One question from Vice Chair.
Thank you, Chair, and thank you for bringing forward the language. So you had mentioned this a little bit, but if you could go into a little bit deeper, what happens if the water goes beyond a county boundary? Because I think when you were doing your presentation, you'd also mentioned that counties can have multiple boards. So what happens though if those boards do not line up to a county boundary? How do you envision that happening and or working?
Thank you to Assemblywoman Anderson through the chair. Really, we would hope they would come together if it was a split basin and they would be a joint board. But in the case they weren't, then they could stand a board up on one on each side, or you could have a board that only was looking at the impacts and the issues in that part of the basin that was in their county.
I'm so excited. I got the question to Senator Gocochea. Yay. Thank you so much. Do we have any idea, though, what sort of workload this would create for our division? Because I think we've all discussed how much work currently that the Water Division has to worry about, and or the counties. Is there any sort of idea of all as to if there will be an increased workload for them, or across county line or otherwise?
Well, I'll respond quickly, and I see Mr. Tippett probably has a different view on it than I do. Yes, it will be some, but again, it won't be tremendous. Again, you have to weigh it out. The benefits of having the collaboration and having the communication between that local government, or in fact, are you going to just send personnel out there to do those measurements and have these discussions and then come down on it? So I think there's an advantage to having the conversations that might even save time.
Madam Chair, if I may. Jake Tibbetts for the record, and I think, there's no, the state engineer doesn't staff these meetings. It's just simply setting the table for conversations. And, who wouldn't want to have a local voice in bringing ideas forward for good management? And so putting the time into a good grassroots process should be a supportable thing, I think, even from the state engineer's office.
Mr. Tibbetts, I'm just going to jump in right here to follow up in what you're talking about. Just to make things a little easier, we know that we've had in the state some boards and commissions that haven't necessarily met as often as we would like them to. If this board wanted to meet virtually, would we need to have anything that said that they could meet virtually, or are they okay meeting virtually and we don't need to specify that that's acceptable?
All right, thanks for the question, Madam Chair. Jake Tibbetts for the record. So the bill does clarify that they are public meetings. So the intent is they will follow Nevada open meeting law. So all the provisions of Nevada open meeting law to allow virtual meetings or virtual attendance and provide that opportunity would be accessible to these groundwater boards.
Okay, thank you. Assemblywoman Brown May.
Thank you, Chair. Thanks for the presentation. I just have one quick question. It says that this board would be within a designated groundwater basin. Is it a single basin? We've talked a little bit about counties. There are multiple basins. Are we talking about a single basin, potentially consolidating basins, a super basin? And how does that all play into this?
Through the chair to Assemblywoman Brown May, well, we'll wait and see where we end up with some subsequent legislation as far as whether we're dealing with super basins or not. But clearly, this is, if it's a designated basin, you would deal with that one, that particular basin, and it would only be that. And if you had multiple designated groundwater basins in your jurisdiction, you could have multiple boards. So I think, again, to make this work, the membership work, again, you're going to have to be in specific basins, and again, they need to be designated basins. They've got to have a problem before you call the board together.
Okay, so with that, I think we're going to have to take our recess to go to the floor. We have to be in our seats on the floor at, in about 6 minutes. And then for the folks in Elko and the gentleman in Las Vegas, we're estimating that we're probably going to be gone for about half an hour. It could be more, but we will be back. And we did hear from Elko that they are going to keep the room open, so you'll be good. If for some reason we do lose you, you do have the information for calling in when the bill you're interested in is heard. And then for the folks up here, obviously, we'll be back. And then for committee members, I think we're okay to leave our items here. And so with that, we are in recess, and we will be back shortly. Okay, we are going to come back out of recess. Thank you, everyone, for waiting. Sorry, my estimate was off. It was legislative time. So with that, Senator and Mr. Tibbetts, if you'd like to come back, I know we have just a couple more questions. So we'll start with a question from Assemblymember Watts.
Thank you very much, Madam Chair. Thank you for going through the bill. I'll just make a comment. I agree. I have a little bit of concern with the proposed makeup of the board. I certainly appreciate the intent of making sure that some of those different interests, the senior rights, junior rights, and the major kind of water user are included. I would like to see some sort of flexibility to have some other potential stakeholders included. I guess one of the questions I have is, so you mentioned in particular Diamond Valley. Do you have any idea of how many, so I know this might be difficult, but so you mentioned that instance of when there was an ask and it didn't follow through. Do you know how many other groundwater boards have been requested but have not been, no action's been taken by the state?
I surely don't, but again, Senator Goycochea, for the record, I don't, but I don't believe Mr. Tippett does. I'm only aware of that one because I was sitting on the commission and made the request.
Understood. I appreciate that. I can follow up with the agency about that as well. And then I guess, so the other question I had is, so this is designated groundwater basins. How many, do you happen to know how many designated groundwater basins we have?
I'm not really positive, but we're technically, I think it's 111, but we have someone in the crowd that can probably answer that.
Thank you. I appreciate that. Again, I apologize. I'm not trying to put you on the spot for an exact number here, but I guess that is one concern, is potentially we could, if some of these stakeholders, so if the counties are interested, there could potentially be quite a few of these boards being established. And then I guess the only other question I have, so, and you spoke to it a little bit, but I was just wondering if you could put a finer point on it for us. Obviously there are voluntary groundwater management plans that a community could come together to develop. There's obviously the critical management area designation that kind of forces that issue. There's other kind of more informal stakeholder engagement efforts. So could you just elaborate, don't need the whole story, but just give a little bit of additional background on kind of what's missing from the local, the local engagement and stakeholder engagement process that you're looking to fix with this bill.
Thank you, through the chair, to Assemblyman Watts, Senator Goycochea, for the record. I guess the big piece of this is the fact you could front load it. We don't want to be in the position where we have to declare a critical management area and bring those pieces together. Clearly, I think it's all about allowing the public, and again, it's 4 years, this board's in place, they serve without compensation. The county's going to bear the actual cost. The only real cost involved in this for the state would be the fact that okay, this is what we think, and giving the advice to the state engineers. So, I realize it'll take a little time, but again, we're going to put that time in place, whether it's with basin engineers or, taking readings in these basins, or actually including the local jurisdictions in that process. And again, I'm flexible as far as the makeup of the board. My key focus is, especially in these rural communities, and maybe a groundwater board might be dealing with 3 or 4 basins in a jurisdiction. You take a jurisdiction like Nye County, it could be huge. And maybe there, to your point, the flexibility is going to be required. It's supposed to be to each basin, but, I think at some point, the county commissioners are going to recognize the fact we don't need 39 groundwater boards in a county the size of Nye County. So, you would see maybe some collaboration and coming together in it. We're real flexible. I just want the locals to have an opportunity to meet with the state engineer and say, well, we think you could do this and it'll help. And I think the state engineer's offices would benefit from that. So thank you.
Thank you for those additional responses. Mr. Tippett, anything to add, or?
Yes, Madam Chair. So Jake Tibbetts for the record. So, currently there's informal things that can be done to try to bring stakeholders together but the formal things are a critical management area that may end up developing a groundwater management plan, or there's no other, or curtailment. I mean, that's what the law requires. This is the first, or if this bill were to move forward, this now creates another opportunity for just a local vetting. And it specifically calls for written advice and recommendations on reducing overpumping in designated groundwater basins. So this would create something in the water law to allow another opportunity for groundwater boards to at least talk about it and talk about ideas. And maybe there are ideas out there that locals would have that we just haven't thought about, or the state engineer hasn't thought about. So this is just to provide an avenue to try to bring ideas to the table. That's all it's about.
Thank you very much. Thank you, Madam Chair.
I don't see any other questions, so if you'd like to step back, and we'll move on. But before we move on to support, Administrator Sullivan, would you mind coming up for a couple of questions? Oh, you're welcome. I know the Vice Chair has a question, and then Assemblyman Watts.
Thank you. I realize this is not a money committee, and so I appreciated as well the fiscal note that you all put in for it, which at this time is 0. However, the explanation itself, once you really dig into it, it creates more questions. In particular, it has to do with, the question has to do with, even in those circumstances of a groundwater board being created, it required a substantial amount of division time and resources. In more recent times, the division experienced a substantial commitment of staff time and resources in coordinating with non-statutorily created groundwater boards and ad hoc groups. I was just wondering if, two things. If, first of all, if you could possibly go into how much more time that was, but then also how this would impact the work and or needs of the department, if there was a way to go into that a little bit deeper.
Thank you for the question. Adam Sullivan for the record, and with me is Melissa Flatley, our Chief Hearing Officer, who can help answer this question. But I think the answer is in part related to the questions that have already come up about some uncertainties about, for instance, how many groundwater boards would be requested to be created, and what the different situations might be around in different parts of the state. And not that it would have, well, I guess it's unpredictable about how much time that would require on the part of our staff to be responsive to different situations and sort of meet the expectations of the groundwater board as it's created.
And Melissa Flatley for the record. Going to the first part of your question, how extensive the time invested now with those ad hoc groups is, and it has been more hands-on, but the bill, the way it's written, is ambiguous about what the role of the state engineer would be in the creation and operation of those groundwater boards. So when we drafted the fiscal note, it wasn't obvious that our role would be limited to simply identifying who those senior water right holders, junior water right holders, and large volume or quantity water right holders are. But it may go beyond that, and there may be research involved. We were talking about this. There may be additional legwork involved in trying to identify exactly who the people are that would be on the groundwater board and going through the process of appointing and having them actually serve on the board. It's just unknown what that part would look like. The testimony today made it sound like we wouldn't be providing support to the groundwater boards. But again, that wasn't obvious in the bill language.
Thank you. And then Do you recall the Assemblyman's question? Or do you want him to repeat it?
Thank you, Madam Chair. So I guess we'll start with two kind of numerical questions, one of which I know might be a little bit more difficult to answer offhand. So we heard about that there was a request that was put forward and ultimately a groundwater board was not created. Do you have any even rough indication of how many of these requests have been received? So basically what we heard in the testimony, there was originally one request that led to the creation of a Clark County, Las Vegas Groundwater Board. And then we heard about Diamond Valley. If you can provide any kind of broader context on how many requests have been received from counties for the creation of these, and then how many designated basins are there, which so that we can understand what the kind of the maximum potential number of groundwater boards that could be created under this would be.
Adam Sullivan for the record. Second question first, the number is around 120 in that ballpark, which is about half of the basins within the state. So on the first question, those are the two examples. We've done some research on this and asked former state engineers and former employees if there's something that we're not aware of now. And we haven't identified any time when a request to create a groundwater board was made and denied, besides that one example in Diamond Valley. The one example where in Las Vegas, where the board was created is the one time that this statute has been applied, and that was done in the 1960s. It was for with a specific intent, and that was when the pipeline from Lake Mead was being constructed for surface water to support municipal growth. The state engineer was working with the county to identify where wells could be constructed that would eventually be served by that planned growth from the pipeline. So once that pipeline was then constructed, was built from Lake Mead, then the groundwater board had served its purpose and it was dissolved in the early 1970s.
Thank you very much, and thank you for the follow-up. And I guess I might hold on my question. I'm just wondering, is the agency going to provide additional testimony in the neutral position at another point, or is this the time to ask the questions?
You're certainly welcome to. I didn't think you were going to because of the way you signed in, but if you'd like to, you're certainly welcome to.
And sorry to put you on the spot. I'm just trying to figure out if now is the time to ask you additional questions.
Adam Sullivan for the record. I was intending to make some comments in neutral.
Okay, thank you. I'm sorry you didn't check that you were speaking, so I didn't realize that you were going to speak, but okay, do you want to hold off?
I will. Thank you.
Thank you very much. Then we'll have you come back in neutral. So thank you. So with that, we're going to go to anyone in support in Carson City. And then if there's anyone in Las Vegas or in Elko. And gentlemen in Elko, I'm assuming you're all here for the next bill? Can you raise your hands if that's true? Okay. All right, thank you. Okay, please go ahead.
For the record, I'm Doug Busselman. I'm the Executive Vice President of Nevada Farm Bureau. Our organization has a number of water-related policies which draw attention to the importance of local engagement. Our support for SB 180 and the ability to form local groundwater boards is based on this foundation. We have a specific policy which states that the Division of Water Resources needs to be more engaged with groundwater right owners to assist in improving water management. In our view, the formation of local groundwater boards will provide a consistent structure to make these engagements more effective. We urge your support for SB 180.
Madam Chair, members of the committee, Kyle Rorink with the Great Basin Water Network. We support SB 180, and I think largely some of you may be asking, well, what does a designated basin actually mean? And I think what we have to think about that is this is a basin that needs some more management, or folks have decided, the state engineer has decided it needs more management, needs to get back in balance. And so, getting people together to come and figure out a solution should be something that we are all encouraging. And I think right now, if you look at subsection 2, really where the conversation has been is about you kind of need a permission slip from the governor just to get this going, just to have water rights users sit down at the table and try and hash some things out. So I think when y'all are considering this, that subsection 2 and the changes that would be made, I think would really help just galvanize getting people to the table, figuring things out before, you get in a situation like where you need a groundwater management plan and you have a critical management area. So getting people to the table talking is something that we support, and we thank you for your time and consideration.
May I ask you a question?
Yes.
So, we had a question earlier about the makeup. Is your organization concerned about the makeup of the bill, boy, we still have one more bill to go, of the board? Because I'll say I had that same concern when I originally read the bill, and I thought, oh, well, why not throw in another engineer? No offense to the, why not throw in someone from environmental? No, why not throw in someone like this? And then the more I thought about it and talked to other people about the bill, I saw the wisdom of the makeup, but I do still see why there might be a concern. And so, yeah, I would like to see what your organization's
Chair.
opinion is.
Madam Chair, Kyle Rorink for the record with the Great Basin Water Network. We don't have an issue with the makeup because largely this is about water users trying to figure out how to get a grip on things ASAP. And you don't, as much as I love to open my mouth and run my mouth, you don't need me there getting in the way. You need the water users to come to the table, figure it out, and let's do it quickly. And let's not require a permission slip, from someone who's very busy like the governor. Let's just get moving on this. So that's where I am.
Okay, thank you very much. Go ahead.
Thank you, Chair Cohen and members of the committee. My name is Jacob Brinkerhoff. I serve as the Natural Resource Manager for the Association of Counties. Our members, as you probably all know, are all 17 counties in the state. Appreciate the opportunity to come and testify on this, and thanks Senator Goachia for bringing this forward. NAGO is in support of SB 180. We believe it simply streamlines and provides clarity to previously approved groundwater board formation process, and that it will finally provide a framework for these boards to actually be formed, where it seems some bureaucratic hurdles have gotten in the way of that in the past. We believe this enabling legislation is a benefit to our members who would be seeking to establish these boards, streamlining the board formation process. And this is a way that will allow county commissioners to advance meaningful local stakeholder involvement and collaboration with the state engineer on the management of a critical resource in our state. Thank you again for the opportunity, and urge your support of SB 180.
Good afternoon, Madam Chair, members of the committee. Chauncey Chowdo on behalf of the Southern Nevada Water Authority. We are here in support of the current language in the bill. And while this bill doesn't impact the Las Vegas Basin, because we already have a advisory committee for the management of groundwater that is statutorily authorized, it could be necessary in other parts of Clark County. So appreciate your support for the bill.
Thank you. And seeing no one in Las Vegas and no one in Elko in support, BPS, if we can go to the phones.
If you would like to testify in support of SB 180, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Thank you, BPS. With that, we will go to opposition in Carson City, and then if there's anyone in Las Vegas, and if there's anyone in Elko, please raise your hand in opposition. Please come forward, sir. Go ahead.
Good evening, Madam Chair, members of the Natural Resources Committee. My name is Mark James, and I'm the company representative for Las Vegas Wave Group to testify in opposition today to SB 180. I had the privilege of serving on the Committee on Natural Resources when I served in the legislature, and so it's a privilege to appear before you. I also chaired the Statewide Water Committee in 1994 that were the last really major amendments to the water law. When you go through the statute, you can see 1995, we made major changes. But we refrained from doing something like this because under the Constitution and the laws of the state of Nevada, the public waters are owned by the people of the state of Nevada. And the water law is set up so that an appointed, non-political, not elected public official in the person of the state engineer is the person who makes the decisions about whether there will be an allocation, an appropriation of water, or a change application which changes the place or point or manner of use of water. It's important that we keep that structure. Groundwater decisions and water decisions like the ones I just mentioned, appropriating waters or changing their place or manner or type of use, must be made by the state engineer. Local input or input on a given change or appropriation of water is provided for in the statute under the protest law. The state engineer is required to publish these as they become ready for action, and anyone who's concerned can protest, and the state engineer will hold hearings. On the cooperative water project, which you all know about, the state engineer held hearings all across the state, and those hearings are probably a very big reason that that cooperative water project has stalled completely right now. So what we are doing, if we require the state engineer to create these boards and then require the state engineer to consult with the boards, is we're changing the structure of the water law. Right now, local people have the ability to give input on any decision the state engineer makes. But the state engineer is the person that the statute from the beginning of the water law in 1913 puts in the position of making decisions about this scarce resource, water, that is owned by all the people of the state of Nevada. It doesn't put local water right holders, of which my group will be one, or is one already. They are not the ones who make the decision. And the state engineer will consider all local input through the existing process. To engraft a required board will do a couple of things. It will change the structure, as I said, away from the original foundation of the water law, but it will also keep the state engineer more busy than he already is. This is probably one of the most busy offices in government, and they already have more work than they are staffed to do. So I strongly oppose this, we strongly oppose this, and hopefully we'll keep in mind that a change like this changes the direction of our public policy concerning water in Nevada. And that direction should not be toward moving the decisions into the hands of local people who own water rights. It should be keeping it at the office of the state engineer, who is a professional and has a professional office. So that's that's our view, and we think it's very important that this bill not pass.
Okay, thank you, sir. I don't think we have any questions.
Thank you very
All
much.
right, thank you. BPS, if we have anyone on the phones, please, in opposition.
If you would like to testify in opposition to SB 180, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Okay, thank you. And with that, we will go to neutral in Carson City. And then if there's anyone in neutral in Las Vegas, please come forward. And anyone in Elko in neutral, please raise your hand. Please go ahead when you're ready.
Adam Sullivan, for the record, I'm testifying neutral on this bill. I do support the concept of the state engineer office working with local communities that are affected by the decisions that we make. This is something that, to the extent that we can, we incorporate in our standard practice now. It's just really important to have good dialogue with stakeholders about what the data is telling us, what the risks might be, and what the law provides for, because we need to be consistent about applying the law equally to everybody. And as well as what other alternatives might exist at the local level. So we do meet now with a number of different advisory committees or boards, county water boards, community groups, other organizations that exist that have been created at the local level that have interests in water resource issues. And I think it's a really important effort that we make to, to get local input as we think through how to apply water law most effectively. I think that the groundwater board, that the concept that's envisioned here, it could be successful in just the right scenario, which is, I think it's this, the scenario that's envisioned by the bill proponents. When we look at it from a statewide perspective, there's just a number of scenarios where that wouldn't be a perfect situation, so there could be some, unintended consequences or problems that would come out of it, or some ambiguity, and that's kind of how we look at it, and just from a practical standpoint of how this would play out. So a couple of examples, and this has already come up in the discussion, but one of the issues is the groundwater basin and the county delineation, because most groundwater basins span multiple counties, and I know that this was discussed, and it could work out. Maybe the counties get along and agree, but maybe they don't, and and if there's a situation where there's different interests on different sides of the county, or if the hydrogeology is such that there's recharge on one side and a lot of use on the other side, I could just see situations where we wouldn't be able to come to an agreement between counties. Secondly, with regard to the makeup of the advisory board, again, in certain situations, it would work great. In other places, in some parts of the state, there would be problems. For instance, there might not be enough individual water right holders to actually fill out the board in some places, or it would be the same people, the senior water right holders, those who hold the most water, the junior right holders. It would be the same people, or it wouldn't be individuals. It might be federal agencies that hold substantial water rights, or other public entities, and how would we handle that? There's also when we talk about senior and junior, it's not a clean line. We have to consider vested water right holders, whether adjudicated or not yet adjudicated vested water right holders. It adds some question about who is a senior and who is a junior water right holder. It's all relative. And then another issue is how many boards would be created. And this is what we talked about earlier. And would we have the time to be sufficiently responsive and meet those expectations, and be able to participate meaningfully and give the board the proper be involved at the appropriate level. And then lastly, there's the concern that we're creating a formality with this, with the state engineer appointing this board that then doesn't really have any authority. And I think I'm saying that correctly. And what that might do is just open up some, again, ambiguity or some just liability, even though I know the intent is that the state engineer's decision would, would not be overridden by the local recommendation. We still think there might be some problem with creating, opening up some question there. And on that topic, I do want to turn it over to Melissa for her perspective. Thank you.
For the record, Melissa Flatley, and with that litigation risk, right now there are many steps that the state engineer takes when implementing regulatory oversight in water rights. And each of those steps is subject to appeal under NRS 533-450 by anyone involved. Having the Groundwater Board make this recommendation is a new step in that process, and it changes the structure of how everything moves forward. And it creates this risk not of getting sued by the state engineer choosing not to follow the Groundwater Board's recommendation, but later when the ultimate decision of the state engineer is different than what the recommendation was that came from the Groundwater Board, there's a new angle to sue for that being arbitrary and capricious, where this formalized board with authority now is put at the same level of expertise as the state engineer has previously provided in deciding matters like this. The risk of increased litigation would increase both in volume and complexity from the litigation that's faced now because of the angle of the recommendations that are coming and the competing ideas that might be brought by the board and the state engineer's ultimate use of that recommendation.
Go ahead.
Erin Sturdivant, Legislative Council Bureau. Just wanted to note that the existing bill does say that the decision not to comply with the view of the Groundwater Board is not subject to judicial review. Obviously, the decision of the state engineer on whatever the issue is still subject to judicial review, and you can't stop people from suing. But the decision itself, whichever way he goes, if he follows the Groundwater Board or does not, is not subject to judicial review.
Thank you for that. And we do have a couple of questions. First, we'll go to Assemblymember Watts.
Thank you very much, Madam Chair. Thank you for the testimony. So just to follow up, I want to follow up a little bit briefly on the concerns that were brought up on litigation. First of all, just to make sure that I and hopefully the other members of the committee have this kind of, the concerns that were laid out correctly, and if not, or if there needs to be some additional clarification. So essentially, if I understand the concern properly, you agree that essentially the act of the Groundwater Board providing recommendations and whatever the state engineer choosing not to act on those recommendations, that decision itself cannot be challenged. So you agree with that, and that's in the bill. But that if that's in relation to any hearing or decision, official decision before the state engineer's office, that once that decision's rendered, that which is subject to judicial review, that in challenging that, a litigant could point to the decision of the Groundwater Board and that could potentially add complexity into the review of that decision, and because of the kind of statutory construction of that groundwater board, it would have, you're kind of implying that it would have a little bit higher standing or a little bit more weight behind it than if it was just a group of people that express some concerns otherwise. Is that, am I kind of laying out that concern properly?
Melissa Flatley for the record, and yes, you said it better than I did. That's exactly right.
I think you did a great job. I was just trying to make sure that I kind of had that understanding of the different processes, and that this process as it's envisioned is kind of its own separate thing, but to the extent that it relates to other official kind of decision-making processes, that at some point that could be kind of brought into the mix in potential legal challenges. I guess the only other question that I have right now is, clearly this has been brought forward, and there's interest in having some additional, more proactive conversations, more proactive processes to try and address issues in certain basins. I know that the state engineer's office has been proactive. I've been involved in some of those stakeholder groups and conversations that have happened, and appreciate those efforts. Obviously, we're hearing about a request for some additional conversations or process, but I was just wondering if you could speak to that a little bit, how you see these things. And again, you mentioned that there are some scenarios where you could see this being really valuable, including what the proponents of the bill have stated. So if you could just provide any additional background on that could help us in wading through potentially in making this maybe something that can work and be helpful in those cases, and maybe supplement some of the current formal processes and informal stakeholder engagement. And then anything else you see that could potentially, outside of kind of the litigation aspect, that may pose an issue around that.
Adam Sullivan for the record. The way we approach public meetings or working with local community groups is, water law doesn't provide a lot of alternatives for how we deal with problems of where there's basically not enough water to go around for the long term. The problems that we see around the state are often initiated generations ago, and so we have to recognize that it's not easy. There's no simple fix to some of these problems, and there's no quick fix. So what's important to communicate to the people who are potentially affected by, say, curtailment or other restrictions on ability to use groundwater use is understanding how water law is written, what the limitations are, and kind of what our role is as the state agency. So it's very much specific to different areas of what the problem might be, what the data is telling us, and who the people involved are. So going back to the question of, or the point that in certain situations, and I think that the bill as proposed is envisioned for certain situations where this would work. I don't disagree that there could be some of those locations. I don't know specifically if there are basins in mind, but I don't really want to speak for the bill's proponent on what they have in mind.
Thank you. And thank you, Madam Chair, for the questions.
Assemblywoman Hanson.
Thank you, Madam Chair. Thank you for being here. I'm sorry, I know it's late, and I know my brain is probably a little bit fried, so I hope I can make some sense. I'm trying to understand, I'm actually thinking, wow, this is like really a great idea. We're here, we are always talking about water issues, we're talking about a lot of these basins, over pumping, and then it seems to me that we're asking for a solution to be had by those who are involved to a large extent there in those communities, where that feedback is so important. I've attended Central Nevada Regional Water Authority meetings and have been so impressed by all those people that are involved, and they regularly meet, and they don't seem to have trouble meeting, and there's a lot of discussion that's so important. And I see that kind of what we're doing here is kind of similar, and that I'm trying to understand what maybe the pushback is, and that you just have to consider the written advice and recommendations of the Groundwater Board, of those people, not act on it, just consider it. And the only really other big change is that a county commission would request that the state engineer, rather than existing language was recommend establishing a groundwater board. So if it's going to add to the workload, certainly we've heard the concerns, and I think we agree there's concerns about staffing and the ability. But if this were to play out and we see that this turns into something that's maybe too onerous for your department, we can maybe fix that when we come back. So I guess rather than a question, more of a statement is I'm seeing that we're finally asking, not finally, but we're asking people who've been a part of discussions about, we have concerns about water and overpumping and issues in Nevada. Now we're asking those people to help come up with the solutions. Rather than you being asked for the solutions, us being asked for the solutions, we're saying, help us come up with some solutions. And I see that as having them have some skin in the game about issues that are either litigious or controversial at the legislature. It brings them in, and now they kind of can participate and understand how complex, and their views can be heard more at a local level. And I see it as a support to you, because believe me, and I've said it before on the record, you have an incredibly hard job. And so unless I'm missing something, I'm seeing this as a great support to the state water engineer, and not overthrowing prior appropriations, not telling that this board is not telling Nevada how to run, they don't have the authority to do what they want with the water. So with that being said, thank you for what you do. I see this as being a help to your office, to your decision-making, and if I've missed something, I stand corrected, because it is very complicated what you have to do. So thank you for letting me make that comment, and if you had something to say and reply, that's fine.
Adam Sullivan, for the record, thank you for that comment. And you bring up the Central Nevada Regional Water Authority, and that's a good example of an existing organization that is interested in protecting water resources through the state. And they meet regularly, like you said. I try to participate in those meetings when I'm available, and it's good to work with groups like that. But that organization doesn't require state engineer appointment. And so one of my hesitations here is that by having the state engineer appoint those people, it gives it a different kind of makeup that would kind of have a different structure. And I'm not sure how that would play out, but I like working with local organizations that are created at the local level with existing authority, who are interested in water resources, and we can have that good dialogue and a collaboration with those groups to work on regional water issues. We, as our role, as the state, we're limited by what water law allows us to do, and that's an important part of that dialogue. And there are a number of things that can happen at a voluntary level to address long-term water resource issues. But there's a separation there of what can happen and be implemented at a local level versus what suggestions we could take and actually implement, because again, we're limited by what water law provides, and we can, well, I'll leave it with that. Thank you.
I have a question from Assemblymember LaRue Hatch.
Thank you, Chair, and thank you for answering our questions on this. So you just inspired another question from the one that I thought, but would it help clear this up or make you more comfortable if the counties that are requesting it were the ones that were appointing the board, as opposed to you being the one that has to choose those members?
Adam Sullivan for the record. I would have to think through that, but my first reaction is yes. That I think is a more appropriate way to do it for a locally developed board of water interests. But there may be some other aspects of that aren't coming to me in this moment.
All right, now on to my actual question. So it seems like the goal of these boards is to, as it says, reduce overpumping. And we heard that there is a method now which is curtailment, or there is the public protest. That's basically how we get public input. But can you just speak to what is being done currently to reduce overpumping and what your role is in that outside of these boards?
Adam Sullivan for the record. So so the first thing that comes to mind is if a basin is deemed to be in need of additional administration for whatever reason, it is designated, and we've talked about that a little bit already. And commonly, a basin is the easiest threshold for designating a basin is if the water rights that are granted exceed what's estimated to be the long-term the water supply. That might be something different than when we say overpumping. Overpumping, when I hear that, I think there's chronic water level drawdown. That might be consistent with appropriations exceeding the perennial yield. It might be a very localized circumstance where there's overpumping. So there's a number of different considerations like that. With regard to what we do and what our role is, the first one is to collect data so that we understand what's happening and we can document what's happening. So that's both with pumping, how much is being pumped, and the monitoring of both water levels and stream flow. With regard, then secondly, what to do about it. There's very limited options provided within state law. We can take some administrative steps to reduce the commitments for water that's not being used. But for water that's actually being used under water rights that are in good standing, we can either curtail by priority, or we can designate a critical management area. The third option I guess I would throw out there is that in local communities, you could have voluntary reductions. And that's what we've been trying to, had some success in communicating with local water users about how much voluntary reduction would need to happen to have a measurable benefit. And that's just to be realistic about curtailment should be a last option.
Okay, I don't think we have any other questions. With that, thank you very much for your willingness to come up and answer our questions, both of you. So So seeing no one else in Carson City, Elko, or Las Vegas in neutral, do we have anyone on the phones in neutral?
If you would like to testify in neutral to SB 180, please press star 9 now to take your place in the queue. Chair, there are no callers choosing to testify at this time.
Okay, thank you, BPS. With that, please come back up and make some closing statements.
Thank you, Madam Chair, members of the committee, Senator Goycochea for the record, and I apologize, and I must tell you, this is a simple bill. So I'm sorry. Just a couple of quick points I'll make, and I know Mr. Tippett has some as well, but one thing you have to understand, if this bill doesn't pass, existing law is in place. You petition the state engineer, and the governor appoints. So I think this is a better mechanism. And, we talked about the makeup of the board. I'm a little concerned, and I've been in local government a long time, but when you get a local community, if they make the appointments, you can get one side or the other actually leading the charge. So we were just trying to put some structure in this on who was going to sit on the board. And then to the opposition to the bill, yes, I agree. You have the ability to protest. That's where the public process starts. But ultimately, it ends up in litigation. And that's what we're trying to avoid. Let's get this headed off at the start with this bill, rather than having to go through the formal protest, advertise, protest. Everybody gets in line, hires an attorney. It's good for some people, but not everybody. So with that, I'll turn it over to, and again, I apologize for the length of time the bill took.
Yes, Madam Chair, Jake Tibbetts for the record, thanks. So again, something that, with all things water, there's apparently no milquetoast water bills, right? So, which we kind of assumed this was when we brought it forward. But just again, highlight, no decision-making authority of this board. It does not subvert the state engineer authority regarding the makeup. The meetings, even regardless of the makeup, they're open meetings, they're public meetings, public comment periods according to open meeting law where every viewpoint can be heard. To address the point about, well, what about the intra-county issues or stakeholders on different sides of the line not being able to come to agreement? Well, not coming to the table at all is never going to resolve agreement. This provides an opportunity to bring people to the table to at least talk about things. So to say that this bill is going to somehow breed disagreement, the disagreements exist already. This is providing a forum for collaboration or a recipe for people to come to the table to resolve those conflicts. The question about the ambiguity about who is junior or senior and our vested water rights, I think the bill, I'll just point out that it is specific that it's holders of permits or certificates to appropriate water, a member of the greatest quantity of groundwater in the basin. So I think it's clear that it's permit holders, certificate holders, not vested rights holders that are part of this process. It's the groundwater pumpers that are causing the issues and need to come together. The ultimate decision the state engineer makes, if somebody's affected, they're going to litigate one way or the other. A groundwater board's decision as being so risk averse to litigation to not stand up some local process to try to work through the issues just because of fear of litigation. If it's a decision regarding water, just like this bill, people are going to be on all different sides of the issue, and it's going to be litigated if somebody feels that they're wronged in that decision. We really believe this will provide an opportunity for people to try to address issues to avoid that. We know you're not going to avoid litigation all the time. But to say standing up groundwater boards is going to increase litigation, we just don't think that is a reality. Thank you.
Thank you, gentlemen, and no need to apologize. We appreciate you coming forward with the bill, trying to resolve as we know, is a serious issue for our state. So we are going to hear the next bill. Oh, and with that, I will officially bring the hearing on SB 180 to an end. So we are going to hear the next bill, but before we start, we're going to take about 5 minutes to let members of the committee take a quick break, a bathroom break, and also we're going to grab some dinner. Most of the members of the committee have been in the building for more than 10 or 11 hours and ate lunch at 11 o'clock. So we're going to grab some pizza and come back and eat it on the dais. And but we will be back in just a few minutes, and not just a few minutes like I thought the last break was going to be just a few minutes, but literally just a few minutes. And we will come back and be here for the next bill. So with that, we will be in recess. Thank you, everyone. We're back. So we're coming out of recess, and we're going to open up the hearing on Senate Bill 269. Senate Bill 269 revises provisions related to animal cruelty. And with that, I will invite up Senator Orenshaw. Please begin when you're ready. And as a reminder, there is a mock-up, proposed amendment 3627 that can be found on Nellis. There's also a one-line personal amendment that the senator is going to explain as well.
Good evening, Chair Cohen, members of the Assembly Committee on Natural Resources. For the record, James Orenshaw, I represent State Senate District 21. Thank you for hearing Senate Bill 269. I would like to tell you that we have everything worked out. It's still a work in progress, but we've been trying to work with a lot of stakeholders. I want to thank your committee counsel, Ms. Sturdivant, with helping me with this bill and helping me with the mock-up. The origin of this bill has to do with a conversation I had with Dr. Karen Lane, who's next to me. Former constituent of mine, not a constituent anymore. She moved over to the other side of town. I believe she is Assemblywoman Brown May's constituent, but used to live over in Senate 21 over on the east side of town. Dr. Lane, besides being a retired professor from UNLV, very active in our animal welfare community down in Southern Nevada, former member of the Nevada Wildlife Commission, former president of the Las Vegas Valley Humane Society, and someone who cares tremendously about animals and doesn't just talk the talk, but walks the walk. And when I've had constituents who've needed an animal rescue, she'll be out there to try to save that animal and make sure that they get the care they need. So I do want to direct the committee to the mock-up that should be on Nellis. The mock-up, the original bill, yes, is right here. The original bill deleted some exemptions that were in statute. The mock-up restores the exemptions that were originally deleted in the bill in terms of the exemptions that are provided for hunting and hunting training. And the mock-up talks about on page 3, well, perhaps I should start with one of the big changes in the mock-up is we are proposing to lower the amount of hours that a dog can be restrained using a tether, pulley, chain from the current amount of time now, 14 hours in a 24-hour period, to 10 hours within a 24-hour period. That's one substantive change in the mock-up you'll find on page 3. Additionally, we are proposing to restore the exemptions that are currently in statute for NRS 574.100 for hunting, the language as to being used lawfully to hunt a species of wildlife in the state during the hunting season for that species. We had proposed restoring the exemption at line C, receiving training to hunt a species of wildlife in the state. And we were proposing to limit that during the hunting season for that species, but I've had a lot of conversations with Kyle Davis. Dr. Lane's had conversations with Kyle Davis, the Nevada Coalition for Wildlife, and I'd like to propose not having any limitation on the time, just restoring paragraphs B and C, the exemptions that were deleted as they are in statute now, and not changing those exemptions regarding hunting or training and hunting. And those are conversations Dr. Lane and I and Kyle Davis have had. Additionally, we're proposing to restore the exemption regarding a rescue operation. However, that's where my one-page proposed amendment comes in. I am proposing that there be a change in the language, and that's in paragraph F, as to the language regarding a rescue, as to temporarily be cared for as part of a rescue operation, comma, in conjunction with an animal rescue organization. The rationale for that is to try to make sure that the rescue organization is really legitimate and is trying to, to help animals and isn't something that maybe isn't really not able to do what it needs to do. That's the concern we had with that and with the original exemption. There are, when we worked on the bill over in the Senate, Clark County and Washoe County came to me and Dr. Lane with concern regarding issues when there are heat advisories and wind chill warnings, cold warnings from the National Weather Service. So that language was added. We accepted those amendments from Clark County and Washoe County. And there are some concerns that were brought to me today by the Public Defender's Office. And I would like to keep working with them on those concerns. And with that, if I could turn it over, with your indulgence, Chair, to Dr. Lane, and then I'm happy to stand for any questions. I can't guarantee I can answer them, but I'll try my best.
Please go ahead, Dr. Lane.
Thank you, Chairman Cohen and members of the committee. I'm Karen Lane. Last spelling is Layne. I really appreciate you taking time this afternoon, or this evening actually, to talk about this particular bill. It is about animals. And I think everybody can agree that we want to do whatever we can to take care of the animals that are in our lives. I would just want to point out on the information about the heat alert. Actually, the heat alert was something that we did add in the bill because that's something that's already being done currently in Clark County and the city of Las Vegas. So if there is a situation where the temperature changes, and it's not just based on temperature, it's actually based on the humidity as well, then the National Weather will put out an advisory letting people know that there's going to be a shift in the temperature, and that's what we're talking about there. So that actually was picked up from what Clark County and the city of Las Vegas are already doing. And I'd also like to add that most of you are probably familiar with this statute because you actually did review AB 86, which looked at areas in the statute, but believe it or not, we actually looked at different subsections of that particular bill. So you probably are very familiar with that. And if I remember correctly, there was a member during that hearing who asked about the question of heat. And so this is your answer to that issue, is that we're trying to address the heat issue. And then Washoe County came in later on and said, hey, we've got just as big an issue with the chill factor, winter storms, and can we add that to that particular area? So that's why you're seeing that in there. And we're hoping that that will address some of the weather issues that we are seeing. The only other point I think that we should talk about is where we talked about reducing the 10 hours from 14 hours in a 24-hour period. So in other words, right now you can tether an animal for a total of 14 hours in a 24-hour period. The problem that most animal protective agencies have with that is that basically if you want to prosecute someone on that, you have to keep a diary. I mean, so the person who's watching that dog sitting out being tethered has to say for 14 hours, okay, so hour 1, the dog, I see the dog being tethered. Hour 2, I see the dog being tethered. And what the animal protective agencies have found out, they may be willing to do that for a period of like 10 hours, but they're much less willing to do it for 14 hours. You know, you think of your life as in 8-hour blocks, right? You sleep 8 hours, you work 8 hours, and then you've got a family to take care of basically for 8 hours. So that's one of the reasons that we talked about reducing that. And if you look at other state statutes as well, you'll see that the 14-hour limit that Nevada has, it's on the higher range of that. Is there anything else you wanted me to? And I think we've talked about the exemptions that have, Senator, you covered those pretty well.
Thank you, Dr. Lane. Thank you, Chair. I'm happy to answer any questions.
Thank you. So I appreciate that this is still a work in progress, and I appreciate all the work you've done with the groups today and all the groups who have been working with you today. And I appreciate all your work over the years, Dr. Lane. But we've had a long day. And so can you briefly just kind of do this as a walkthrough and walk us through where you are right now?
Chair Cohen, James Orchell, Senate 21. Walk through the bill or walk through where we are with the other stakeholders?
Walk through what you're proposing right now. So where you are with your amendments, what you're suggesting, the bill as it stands right now, what your proposal is, with the caveat that I understand you are still talking with stakeholders, and but if you were to get, if you had your druthers and you got it passed out the way you wanted with no more changes, where would it be today?
Well, in the ideal world, I'd want, ideally, there'd be no exemptions, but I understand there are good arguments for exemptions, and
Or, I'm sorry, not, let me rephrase that, not if you got everything you wanted, but where you are at with level of agreement today. As it stands today, if you had no more agreements with stakeholders, where the bill is at.
where the bill is at, I believe, with my proposed verbal amendment to the mock-up as to on page 3, subparagraph 4, regarding restoring the exemptions for hunting at paragraphs 4B and 4C, I would propose deleting the green language that says that training would be limited for the hunting season of that species. I would propose restoring it just to the way it is in statute now at NRS, let's see, it's 574.100. With that, Mr. Davis told me that the Coalition for Nevada Wildlife would be neutral on that bill. We've had some good conversations today with Mr. Pirro and Ms. Roth, and I'd like to continue those conversations. The concern was the unhoused community and how this law, especially with the heat and cold warnings issued by the National Weather Service, how that would affect the unhoused. And I understand that there's language that was amended into Assembly Bill 86. I believe that's a little too broad. I believe that there's a way to more narrowly address the issue of the unhoused, and I think that I'd like to work on that with Dr. Lane, Mr. Pirro, and Ms. Roth, but I don't have agreement there on that yet. I'm not aware of any other groups that have reached out to me about this bill.
Okay, so I have several questions. We will start with, let's see, Assemblymember Yurika.
Thank you, Chair, and thank you guys truly for your passion for animals. I can tell you that I was the commander for a police department canine unit and have a true heart for those dogs as well. And as I was reading the bill, I'll be honest, and as I was looking at what you were targeting, I was really quite curious as to how extensive is the problem that you're trying to address? Because as I look at the exemptions that are in statute and the attempt to remove them, these are like dog lovers. These are, I'm just took my notes here, veterinarians, hunters, and I realize we're maybe making an exception there, dog trainers, people that show dogs, dog breeders, boarding facilities, rescue operators. I mean, these seem like people that would have the utmost compassion, know their dogs, and want to take care of them. And yet we're trying to get them out of the exclusions for some of this. And so I guess my question is, do we have a widespread problem with these traditionally very passionate animal lovers that are abusing the dogs in some way that I'm unaware of? So that's one question, if you could address it. And the other question, and Chair, if I might just throw it on here, it's the 14-hour to 10-hour. I might suggest, because again, I'm going to go back to my experience as a police officer, 10-hour work shifts. We, in Las Vegas in particular, right, we have the 12 and 10-hour work shifts is very, very common, and that might be why it was up there. So you might want, I don't know if you care to comment on that. Thank you.
Thank you for, Karen Lane responding to you, and its reference, I will say this to you. When we talked about this originally, this portion of the cruelty statute is a very critical one. And it was added in 2009. And it was, at that point, it was, I will say, because I actually attended the hearing on that very first hearing. It was a very difficult bill to get passed because at that time, tethering was something that was done to maintain control of the dogs. There was a widespread use of it. And I can tell you that Clark County Animal Control, for example, said they were going to be neutral. They weren't committing. One of the things because of that, if you look at the exemptions, as you point out, are very broad ranging. I mean, they cover a wide topic of areas. And it doesn't make sense, this is 14 years later, that there are so many broad exemptions and there were issues. So one of the things that we did was we actually talked to some of the animal protective groups and said, what are the issues? there are problems with boarding facilities. There have been problems with boarding facilities. I know personally, and I've also talked to other people, there have been issues with rescues in terms of the not tethering so much as, if you notice, there's a section that we didn't address, and that's on the size of the caging. And that has been a very big issue in the sense that too oftentimes the caging is often too small for the animal. So I understand what you're saying, that yes, everybody's a dog lover. There's no doubt about it. But yet we know from experience that there's always about that 10% that are not responsible pet owners. And those are the ones that we have to look on. I think that everyone works hard to be a very good and responsible pet owners. But if you talk and look at your community sometimes, you will see that there are problems in this area that are trying to be addressed, and it makes it difficult. And that's why I was pointing out the 14 hours. It's very hard for somebody to look at that animal for 14 hours. Yes, you may be correct that if you have 10-hour shift, it's more difficult. But I will say this to you. If you look at the weather problems now, I don't think in Las Vegas during the summertime, when it's your average temperature during July, I think in 2022 was 103 degrees. I don't think that we should just think about tethering that animal outside. I mean, that's a long period of time for an animal to be tethered in a 24-hour period. And that's why we're talking about reducing it. Does that help to answer your question?
And Chair Cohen, James Ornshaw, Senate 21, just want to also address the exemption issue. Most of the exemptions that we sought to delete through the amendment are being restored. There is a tweaking of the language regarding rescues that we are trying to make sure they are working in conjunction with an animal welfare organization. Additionally, you mentioned law enforcement, and I believe there's a new exemption proposed in Assembly Bill 86, sponsored by Assemblywoman Hardy. As I understand, if her bill passes and if this bill is lucky enough to pass, I don't believe there's a conflict. I believe that exemption would still go forward because this bill does not address that or try to delete that.
Assemblymember LaRue Hatch.
Thank you, Chair, and thank you for joining us once again in Natural Resources. I have a couple of questions. I think the first one is with the winter storm warning or the heat advisory. My question is, if I'm at work and suddenly a winter storm warning rolls in and I wasn't expecting it, would I now have to go home and bring the dog in or else be in violation of this law?
Karen Lane speaking. The heat advisories, for the most part, are usually issued anywhere from 2 days to 7 days ahead by the National Weather Service because they can pretty much determine that that's going to be the case. So there is always a really good forewarning of those weather alerts. I don't really think that you would see that as a problem for the most part. You would know, people would know about it in advance.
Can I follow up to that? And I appreciate that might be the case for heat warnings, but coming from the north, I know that storms can roll in very, very suddenly up here. And so I just wondered what happens in that circumstance when a storm that we did not expect, much like yesterday when we got a bunch of snow, right? That we didn't expect rolls in. What happens?
James Ornshaw, Senate 21, through you, Chair, to Assemblyman LaRue Hatch. You know, that amendment as to the cold warning, we started off with an amendment that was proposed by Clark County as to the heat warning, and Washoe County asked us to consider the cold warning amendment. And, you know, I don't want to speak for them. I know Mr. Rogan was not able to be here from Clark County, but what happens in Washoe County, that's information I don't have, but I could try to find out because, like Dr. Lane said, I know that normally I'll see those forecasts in advance, but if something happened, hopefully, you know, any animal control officer would take that into account. We did have someone from Clark County Animal Control, but they weren't able to be here this late who could speak to that. So I don't have an answer to that. I hope that Animal Control would take that into account, especially if it was not posted prior to that day, if it happened all of a sudden. But if maybe there needs to be more specificity here, certainly, you know, open to that.
Okay, thank you so much, and I appreciate that you might not have that now, and so I'll look forward to that. My other question was just on a clarifying of the exemptions being brought back in. So I'm looking at page 3, let's see, line 31. So it looks like there's a line that's crossed out that says temporarily in a camping area. Can you just clarify, does that mean that if I am camping with my dog and a storm rolls in, that I'm now in violation, or is there something else that I'm missing about that line?
Karen Lane, through the chair to you, Assemblywoman Hatch. We did talk about this in the Senate hearing, and I think one of the reasons we took out camping is that calls for animal protective services are generated, like police calls as an example. So somebody is going to have to complain about you camping with your dog. And that's one of the reasons we took that out, is that we felt like that just seemed to be overly broad in terms of looking at that as an exemption, because most people are going to camp. You're obviously going to make sure your dog is close to you. I mean, that's one of the things in wildlife. We see a lot of issues with dogs who may run off. They may hit a trap. So, the various reasons why you want to have your dog close to you. So that's one of the reasons why we didn't see that as a big concern of putting that in there. And the other one that was left out on that was the boarding facilities. That was originally included, and that was taken out because there are some major problems with boarding facilities right now in terms of some of the violations that are occurring there.
Assemblyman Gur.
Thank you, Chair. I'm pretty sure my question just got answered, but I want to make sure it did. You're saying you left the exemption for camping in, or you took it out? So camping's included or not included in the prohibitive part of this bill?
James Orchall, Senate 21, through you, Chair Cohen, to Assemblyman Gur. Camping is being deleted, as is boarding facility at line E.
Okay.
As an exemption to the statute.
Thank you.
Assemblywoman Hanson.
Thank you, Madam Chair. It's good to see you. A couple of questions. I wanted to clarify that I understood it right, because I looked at this, but then I think I heard you say the amendment is 10 hours, but I thought it was 14. It says 10 hours here, but then I thought maybe you verbalized 14 hours.
James Orchall, Senate 21, through you, Chair Cohen, to Assemblyman Hanson. The current statute says that a person cannot keep their dog restrained via a tether, a choke chain, a prong chain for more than 14 hours total within a 24-hour period. I'm proposing to change that to 10 hours.
Perfect.
Within a 24-hour period.
Okay, then
So
I-
that would
perfect.
be new language in the statute. That 14 hours has been there at least since 2009, if not longer, but I believe it was 2009, it was put in statute.
Okay, I just want to make sure I had read it right, heard right. The other thing is, so in the, and I know this is existing language, not less than 12 feet on tethering an animal. It can't be less than that. So the concern that I have is that, and again, it's existing language, but sometimes we need to tether shorter. I'm more worried about coyotes than I am traps. And so if I'm somewhere and because I have a small dog, I want my dog tethered closer to me, and it's going to be less than 12 feet. So I guess all this years I've been violating the law. Is that my understanding? I can't tether my small dog less than 12 feet where I'm concerned about their safety?
Chair's indulgence, I'm going to consult with my star witness and my expert here. That's how James Orchall, Senate 21, through you, Chair Cohen, to Assemblyman Hanson. As I read the existing statute, that's the 12 feet is at NRS 574.100. That's the.
So, okay.
Unless I'm misinterpreting
here I am,
it.
bring the handcuffs, I'm sorry. And just, if I can follow up with
Well,
one
we
last
can
thing.
ask legal.
Okay.
Erin Sturdivant, Legislative Council Bureau. That's true, but there is an exception for temporarily in the custody. So if it's for less than an hour, you can use a tether that's under 12 feet long.
I'm still guilty. But I'm honest. And the last question. So in regards to, there's unfortunate proliferation of homeless people, and I see so many of them with pets, which is endearing. So what happens in those circumstances where, especially here in the north, you know, the temperatures, those winter storm warnings come in, and we have homeless encampments in different parts of town, and these animals, you know, are tethered. What happens in those circumstances with them?
James Ornshaw, Senate 21, through you, Chair Cohen, to Assemblywoman Hanson. As to what happens with particular animal control agencies right now under the law, I might have to defer to Dr. Lane. But certainly when I accepted the amendments from Clark and Washoe County as to extreme heat warnings, extreme cold warnings, you know, at first glance, it certainly seemed like the right thing to do. And as to the question of how this will affect the homeless, the unhoused, that the bill does not have an adequate response right now. Certainly, I don't want to make a criminal out of someone who's lost their housing or is living in their car and trying to take care of their dog the best they can. So I've certainly in talk today had some talks with Mr. Pirro and Ms. Roth regarding possible amendment as to the current law regarding the 14 hours and the 24-hour period. Certainly that's the current law right now, that you cannot keep a dog tethered up more than 14 hours within a 24-hour period. And there's no, in the enumerated exceptions, there's no exception for the unhoused. There's the camping exception, but I don't believe that was ever meant to apply to the unhoused. But as to what's happening at local animal control agencies now, that I'm not sure if you have any information. We did have someone from Clark County Animal Control, but they weren't able to stay this late up. So I might be able to find out and get back to you on that, but.
Karen Lane, through Chair Cohen to Assemblywoman Hanson. I would say that in Clark County, this has been a big issue that we talked about in terms of what happens now. And so there are cooling, but this is Clark County, there are cooling centers. So when there is a heat alert, the county sets up cooling centers, and dogs are permitted, animals are permitted to come to the cooling center with their homeless person, basically. But that doesn't address the issue in other counties, particularly in terms of the cold weather. And I know that that's certainly, right now, the statute says for anyone, if the weather goes below 55 degrees, you have to provide additional warming. That is in the current statute says that outside of the tethering issue. So clearly, there is an area that probably needs to be addressed.
Assemblymember Watts.
Thank you, Madam Chair. Thank you, Senator and Dr. Lane, for bringing this bill forward for our consideration. Also, I do want to just take a moment to express my appreciation, having talked with some of the sportsmen about making both the initial change in the proposed amendment as well as the further change verbally to restore B and C as they currently stand in the law today. So I just wanted to express my gratitude for that. I think that makes a lot of sense. First of all, I have a couple of questions, if that's okay, Chair. And I'm just trying to really get acquainted with the statute as it stands and how it's intended to be implemented. So what I can see here in Section 1, Sub 2, except as otherwise provided in essentially the exemptions, a person shall not restrain a dog, and then it has using a tether, chain, tie, trolley, or pulley system or other device and then it has the length requirement, allows the dog to reach a fence. So basically, a person shall not restrain a dog using any of these various chains or tethers. Then B, restrain them using a prong, pinch, or choke collar or similar restraint. And then we have the new proposals here, and then we have the time period. And there, it looks like both the original and the added language is "ors." So my understanding is that restraining a dog is kind of the core of this, and restraining them in any of these individual various manners is prohibited. Because I heard at one point you mention using these specific types of prong, pinch, or choke collars, and then I heard also references to the times. But my reading of this is that it's not kind of some of these other things for this period of time, or some of these things with those restraints, but it's any restraining that fits any of these subcategories. Is my reading of that correct?
James Orange, Senate 21. I believe your reading of that, through you, Chair Cohen, to Assemblyman Watts, I believe your reading of that is correct, and I believe that any of those would violate the statute. However, I believe the time period, the 10 hours and a 24-hour period, I believe that is specific. Certainly it's specific to the tethering, and I believe that's specific to the tethering. And then I think that some of the other paragraphs give more specificity about the conditions, the collar, but I believe that's how I understand the statute, that the 14 hours within the 24-hour period that's the total amount of time in a 24-hour period that a dog can be tied up and not be allowed to roam free.
So essentially this proposal would be for any period of time outdoors during these advisory conditions would be a violation of the statute. Is that the intent?
Through you, Chair Cohen, to Assemblyman Watts, I believe we would be lowering it to the 10 hours, not for any period of time.
Okay.
10 hours for the chaining, unless I'm misunderstanding the current statute, and if I am, I'll use my lifeline to Dr. Lane.
And we do have legal here as well that might be able to help on this. And I'm sorry for taking up so much time, but I will have one more follow-up if it's okay, Chair.
And I'm sorry, I'm sorry to jump in again, James Orange, Senate 21. Certainly, I think the time limit would not apply to the heat advisories, if there's a heat advisory in effect.
Right.
I believe the time limit applies to the tethering, and if I'm misunderstanding, then I apologize.
No,
and
that was the clarity. So any amount of time that a dog is restrained outdoors, when these heat advisories, excessive heat warnings, wind chill warnings, or winter storm warnings would be in violation of the statute as proposed under the bill.
That's my intent, correct?
Okay.
And whether my language has managed that,
I think
Chair Cohen, to Assemblyman Watts, that's my intent.
Okay, I think that is correct. So I just wanted to make sure that was clear. And then in the exemptions under, I guess what was originally E, and I'm not going to try and figure out where the lettering is at right now. You have the proposed additions around under the direct custody or control of a person, if the person's engaged in a temporary task or activity with the dog for not more than 1 hour. And then again, you have the added clarification, as long as there's not the various advisories or warnings for weather. And so I'm just wondering if you can speak to what was this envisioned, and ultimately what is kind of the definition of restrain? Because I'm just wondering, do leashes count? Does this encompass walking a dog? Sorry.
James Orange, Senate 21, through you, Chair Cohen, to Assemblyman Watts. We did discuss this over in the Senate hearing, and certainly my intent is not that anyone walking their dog would be violating the statute. Although when there's the heat and cold warning, that is where certainly we want the animal to be protected. And if I'm not explaining it correctly, I might use my lifeline to Dr. Lane here on this one too, but certainly this is not meant to criminalize dog walking. That's for sure.
Thank you. I appreciate you getting that on the record. And again, I think there might be I might be interested in some additional follow-up on that. But so it sounds like it's essentially being kind of restrained, unattended, outdoors for any period of time when these extreme weather conditions are in effect. So I appreciate you providing some clarity. And I guess I'll just put a comment on the record that I certainly encourage you to work with the public defenders to address the issues of unhoused populations. Thank you.
Thank you, Assemblyman Watts. Thank you, Chair.
Okay, committee, do we have any, oh, okay, let's go ahead.
Thank you, Chair. I want to follow up on the Assemblyman's question about H. I think I want to ask legal. Would a dog lead or a leash qualify under subsection 2A?
Erin Sturdivant, Legislative Council Bureau. I think the current statute is ambiguous as to the extent to which a leash constitutes a tether. I don't think it's intended to prohibit anyone from walking their dog, but it's not clear in the existing language.
If it is, then it's illegal to walk your dog more than an hour. And hopefully that's not the intent of the law.
And James Orange, Senate 21, through you, Chair Cohen, to Assemblyman DeLong. Certainly, that's not my intent. And as I've looked at this statute through the years, and certainly remembering the battle back in 2009, what I always understood this statute, at least to intend, if maybe the plain language doesn't accomplish it, was that prohibition on conditions where an animal is tied to a post, not being under control of a human being, left outside, tied up, and that's where I understood this statute to try to protect dogs, so not dog walking.
Thank you for that.
If I could jump in, James Orange, Senate 21. I'm certainly open if there's a way I can clarify the statute. I'm not adverse to friendly amendments, as long as they're friendly.
Thank you, Senator. So I think we don't have any other questions. And I think all the questions were answered that I had. But I am going to make a statement. I have a history of doing pet rescue, right? The vast majority of my adult life, I did pet rescue. I think everyone loves pets, as you said. I take it very seriously. I take the welfare of animals seriously, but I am not looking to criminalize the unhoused having pets. Additionally, just today, we had winter storms in northern Nevada. Also, not only do we have heat in Las Vegas and southern Nevada all the time almost, but Reno is the city in this country that's warming the most. So I just want to be really careful that we're not setting people up for failure with their pets. While keeping in mind that we do want to keep pets in good condition and that no one wants to see a pet outside on a stake that's stuck there for its whole life. But we have to kind of balance things and make sure that we're being fair to the owners at the same time that we're making sure that those pets are being taken care of. So with that, okay, go ahead, Assemblymember DeLong.
Thank you for the indulgence, Chair. I want to follow up again on H, on page 3, lines 41 through 43. I understand adding the provisions on the heat and the cooling, but what is the intent of that, the exemption for 1 hour? What are we trying to restrict that happens for more than an hour?
Karen Lane, through Chair Cohen to Assemblyman DeLong. We had actually taken that out, and we put that back in because Clark County requested that, saying that when people, they're thinking about the recreation areas, when people have picnics, and they're doing something like that, they have their animals with them. So they were just trying to account for that time period, basically. So has nothing to do with walking the dog, but it's when you're doing an activity in that situation. And I think they were just trying to cover those situations, basically.
At James Orange, Senate 21, through you, Chair Cohen, to Assemblyman DeLong. But with the work we did with amending this with Clark County, I think the concern was that people, if they were out for an hour at a picnic and they were to tie the dog up to a post, that it not be during one of these extreme warnings, heat or cold, issued by the National Weather Service. So the exemption stayed with some changes, but not during those extreme heat or cold warnings.
Okay, thank you. With that, I think we're going to go on to support. So if you'll step back, I don't see anyone in Las Vegas. If anyone in Elko is in support, please raise your hands. Anyone in Carson City, please come forward if you're in support. Okay, seeing no one in Carson City, Las Vegas, or Elko BPS, if you could go to the phones, please.
To testify in support of SB 269, please press star 9 now to take your place in the queue.
Yes, good evening. For the record, Fred Volz, V as in Victor, O-L-T-Z. I'd like to speak in strong support for the amended version of SB 269. I'll make 3 quick statements along those lines. First, it should be indisputable that Nevada needs to protect its dogs from extreme weather conditions. We do need to cut the hours of continuous tethering, which is independent of dog walking. And finally, responsible dog owners ensure their dogs are safe from extreme weather, just as they would for their children. The standard should be no different. Thank you.
There are no more callers to provide support testimony.
Okay, thank you. With that, we will go to opposition in Carson City. Anyone in opposition, please come forward and fill up the chairs. And then if there's anyone in Las Vegas, which I don't think there's anyone in the room, you can start to fill in the chairs, and then we'll get to you in Elko momentarily. Please go ahead.
Good evening, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office. Per the rules of the committee, we are testifying in opposition this evening. We do appreciate the senator for working with us. He has worked with us through our initial concerns regarding the exemptions, and so we appreciate those changes that have been made. Our concerns are specific to how this will impact the unhoused community. You know, there's no way around it. If you do not have a home, you cannot bring a dog inside. Or cat or whatever pet that you have. I think it's great that we're hearing that Clark County has warming or cooling centers, but that is not true across the state. And until we invest in housing for everybody or the ability to bring a dog or cat into a warming or cooling center, we need to exempt those people. Pets are lifelines to our unhoused community. And then I just want to bring up that a lot of the questions are very on point, that some of the issues that are raised when we start legislating this is that all pets are different and they have different needs. So I can tell you that my dog would probably bite me if I told him that he was never allowed to go out in a winter advisory warning ever again, because that's his favorite thing to do. And so I think that we need to consider that when we are legislating this. The counties do have the ability to make more specific laws or ordinances in regards to the weather or issues in their communities. But when we're looking at this at a state level, we need to really consider how this is going to impact different people, different pets, different situations. You know, I treat my dog like he's my son, but there are working dogs out there who are happier being treated a different way. So thank you. And again, I appreciate the bill sponsor working with us through these issues.
Thank you, Chair. John Pure from the Clark County Public Defender's Office. I echo most of the comments of Mrs. Roth. However, in listening to the conversation between the committee and the presenters, more things were brought up that were of concern. So initially it started with the unhoused population, but the camping situation I just wasn't exactly clear on, and then making Assemblywoman Hanson a misdemeanor, I wasn't not a huge fan of that either. I do. And I was like, please stop confessing on the record.
I will say, as a fellow member of the Judiciary Committee, I was thinking the same thing, so.
So this seems like a bill with very good intentions, but I think it's going to need a substantial amount of work, and we're more than happy to work with the senator on this issue. Thank you.
Thank you. Do we have anyone else in Carson City? Okay, folks in Elko, are you in opposition? Or, okay, if you'd like to make statements, you can take turns making statements.
Rich Sandoz, I live in Spring Creek, Nevada. First of all, I like the exemptions in where we can still use hunting dogs. But they mentioned that they can only be trained during the hunting season, and yet there's trials for bird dogs, hound dogs during the summer, and those are training.
And I'm sorry, sir, I know there was
Which we need to have.
I'm sorry to interrupt, sir, but that was removed. The sponsor did a lot of work today, even late into the afternoon, so the.
I know, I said I heard it was put back in.
Right, yeah, but even the training part is out, so you can train year round.
Well, the gentleman sitting next to Ms. Lane said that you can only train during the hunting season. Maybe I'm wrong.
No, that was
but
changed.
Now, let me just. Let me know when I can talk. Let me know when.
Please go ahead.
Okay. I'm going to go to the weather conditions up here in Elko. Even if you have a heat advisory, it's 102 degrees maybe. A dog's normal temperature is 101, 102. Yeah, they need water. Yeah, they need shade. But personally, the springtime and the fall time, my dogs, I want them outside to get acclimated to the weather because they're going to be out. I hunt wintertime, middle of winter, and in the summer. Middle of winter, my dogs have to be acclimated to there in case they get on an overnight trip. And that's happened. Okay, so the dogs have to get acclimated to the weather. So I'll leave them out most of the day when it starts warming up. When it gets cold, they're out, until their hair gets grown and all that. That's all in the spring and summer, the hair growth and the shedding stuff. So, I take care of my dogs, and I think most people do. And yet, you're coming up with these laws that are saying that I don't know what I'm doing, basically. But now I got another question for you. First of all, I would think that a veterinarian should have some input in this on what kind of heat the animals can take in that and the cold. And for instance, people think because the dog's panting, it's dehydrated. That's not true. Panting is a cooling mechanism. You grab the back of their neck, pull it up, let go, it falls down. They're not dehydrated. If it stays up, they are. So now the last point I want to make is, what are we going to do about the coyotes? Coyotes are out in that stuff no matter what. If there's a man-made heat alert, they're out there. You can have a dog under shade with water available in 105 degrees even, I would say. Mine, I don't have that extreme temperatures. But anyway, there needs to be a little bit more common sense, I guess, on this. Thank you.
Thank you. Next person in Elko, please go ahead.
My name is Dave Gowan. I live in Spring Creek, Nevada, representing myself. I'm just want to thank you guys for letting this happen where we can come and be involved in this. It's really, really important to us here. But this bill is really confusing the way it's been all the multiple different ways, but I just want to say that, just what this bill seems to be implying is that most dog owners just aren't capable of making responsible decisions of how to care for their animals safely. I just don't see the evidence that says that we all need to be told how to handle our animals this way. Where's the list of all the violations and all the things that have gone that are triggering this? There's just someone's opinion or misguided over care of animals that, and it's their imagination. The other thing is that what happens in Vegas is in Vegas, and you could have your own regulations in Las Vegas for heat regulations without trying to enforce it on the entire state. The other question I have is, okay, apparently in this bill, dogs that live on farms and ranches just don't count. It's just the dogs that hunters have or regular people have that need to be treated this way. The other thing is we need some definition on what outdoors and indoors means. If you have a dog that's on a tether, but tethering is actually better than kenneling. Most dogs function better if tethered properly. Just because they're on a tether doesn't mean they don't have a heated doghouse that they can crawl into, or a really shaded area with water, and maybe even a pool over here that they can crawl into to cool off in. Now so you're saying a tether is somehow this cruel item that doesn't allow a dog any safety, which is wrong. It's totally wrong. It's just being misconstrued in this context. What is outside? What is inside? Is it inside a doghouse? Is it inside a barn? Is it inside your house? Do I have to bring my Great Pyrenees inside in the winter? That dog that's designed to live in basically Arctic temperatures? If I bring him inside, he's going to have a heat stroke. What are we talking about here? We have some clear definition because you're criminalizing dog owners across this state. Especially, when it comes to hunting. I hunt with my dogs. I make my living with my dogs. I care about them. Just because I'm a hunter, sir, doesn't mean that I don't care about my dogs, for your comment. I raise them. I make my living with them. I camp with them all the time. If I don't tether them in camp, it's against their safety. And it's also against the safety of the wildlife in the mountains that deserve to not have a dog just running loose at random. And also I can lose those dogs in the mountains if I don't have them tethered when I'm not actively hunting with them and have a tracking collar on them. And they need to rest at that point. So it's for their safety and also the safety of the animals in the mountains. That it just goes on and on. I could go on and go on and on about it, but I just really disagree with this bill. I'm all for the safety and not leaving a dog chained up all the time and the pictures you see on late night fundraiser shows or commercials, But the truth is that most of us out here really care about the animals, and we don't really need to be told how we should do it. Because we look at heat advisories and cold advisories, and we make decisions on that already. Because we're responsible adults. We're all responsible citizens. Yeah, there is always this factor, but that is across the board in our society. There's always a factor. So we're going to punish all the responsible people for the acts of a few. Thank you for letting me speak.
Thank you. Next person in Elko.
Josh Austin. I live in Spring Creek, representing myself. I strongly oppose this bill. Like my friend ended up saying, we do love our dogs. We do follow the livelihood of being able to have our dogs. I think this bill before you guys made the amendment, and I appreciate you guys working out keeping the original. This was almost, it seemed like a personal attack against hunting community as houndsmen and houndswomen. We do take care of our dogs. Like you said, we make our living with our dogs, and just want to say that I oppose it. Thank you.
Thank you, sir. Next person in Elko.
I think that's it.
Okay, thank you all. So with that, BPS, we will go to the phones, please, in opposition.
Chair, the public line is open and working, but there are no callers at this time.
Okay, so we will go to neutral in Carson City, and then I don't think there's anyone in Las Vegas or anyone in Elko, so please go ahead.
Good evening, Madam Chair, members of the committee. Nick Vanderpool with Flint Judici Government Affairs here today on behalf of the Nevada Humane Society, Northern Nevada's no-kill shelter. On this topic, as we all know, this is very passionate when it comes to pets. I remember last year working with Mr. Pirro and his former colleague from Washoe County, spending countless hours trying to get a bill right. And so Nevada Humane Society is always willing to work on these pieces of legislation because it is a very sensitive space. So we appreciate the sponsor and look forward to working with them.
Madam Chairman, committee members, Larry Johnson, President, Coalition for Nevada's Wildlife, thank you for this opportunity. I want to thank Senator Earnshaw for working with our representative in the deletion of, number one, the hunting aspects of this, and then secondly, the training aspects. As long as those amendments are adopted, we are in a neutral position, and the only thing I would add further is that we are incredible pet lovers, and my Brittany sleeps with me, and my wife says it's a very good thing I can't get my horse in the house, so thank you.
Good evening, Madam Chair, committee members. For the record, my name is Steve Walker. I was unaware of the amendment when I signed in, so I signed in opposition. I would hope the Secretary would move me to neutral. Did that again. We're in opposition because of the hunting dog exclusion, and so that's moving us to neutral. But during the testimony that we've heard during the hearing, there's still issues with this bill, and we recognize that. Thank you.
Thank you, and then I don't see anyone else, but BPS, if you can go to the phones, please.
Chair, there are no callers at this time.
Okay, with that, Dr. Senator, if you'd like to come up and make a brief closing.
Chair Cohen, James Ornshaw, State Senate 21. Appreciate you hearing the bill. Appreciate the committee's indulgence at this late hour. I just want to remind everyone and to all the passionate speakers in Elko, we are restoring both paragraphs regarding the hunting exemption and the training for hunters exemption. The current agriculture exemption stays in the statute. That's not deleted in this bill. So dogs being used in agricultural settings are not subject to this statute. As to the current 14-hour limit within a 24-hour period, Dr. Lane and I looked at statutes around the whole country, and I believe 14 is one of the higher limits in the whole country. Many states have 10 hours, 8 hours, so 14 is still one of the higher hours. As to what the chair mentioned, as to the issues the unhoused face, certainly this bill is not meant to try to criminalize being homeless and trying to take care of your dog. And that I want to clarify that, because we accepted Clark and Washoe's amendments. They seem like good amendments. No one, should have their animal, their dog tied up during an extreme heat, extreme cold warning. But we need to make sure that this does not criminalize the unhoused who are dog owners. Certainly, dog walking, never my intent. I don't believe that the statute was meant to address people out walking dogs. My understanding of the statute was that it was always meant to address someone who ties a dog to a post or something like that and leaves the dog out. Never meant to criminalize dog walking. Certainly, I don't think that was the intent 14 years ago. With your indulgence, Chair, may I turn it over to Dr. Lane?
Please, briefly, because we have to go move our cars out of the garage.
Thank you, Chair, and thank you, Committee, and thank you, Dr. Lane, for flying up. Appreciate you hearing the bill.
Thank you. With that, we will take, I am closing out the hearing on SB 269, and I'm opening for public comment. Anyone for public comment in Carson City? Seeing none. Seeing no one in Las Vegas? Anyone for public comment in Elko? Seeing none. BPS, anyone on the phones?
Chair, the public line is open and working. There are no callers.
Okay, with that, we are adjourned. Thank you.